When the Supreme Court hears a challenge to the Defense of Marriage Act, the issue they'll be considering is whether the Defense of Marriage Act violates the equal protection of the laws. This presents a bit of a difficulty from a constitutional basis, because the equal protection of laws is language that's based in the 14th Amendment, and the 14th Amendment applies only to the states. So technically speaking, the equal protection provision of the Constitution does not apply to the federal government. Yet the Supreme Court is not going to be stuck on this particular issue, because some time ago they decided that in fact the equal protection provision found in the 14th Amendment will also apply to the federal government. They confronted this issue in a case as a companion case to the famous Brown versus Board of Education decision of 1954. The Brown case consolidated litigation from 5 different parts of the country: Virginia, South Carolina, Kansas, Delaware, and the District of Columbia. In order to decide the District of Columbia case, they had to pull off from the Brown decision a separate case, which went by the title of Bowling versus Sharp. And in Bowling versus Sharp, the Supreme Court said that even though they're deciding this under the Due Process Clause of the Fifth Amendment, they're going to read the Due Process Clause to include an equal protection component. The Supreme Court, under Chief Justice Earl Warren, said that it would be unthinkable to hold the federal government to a different standard than they held the states under the Equal Protection Clause. So when the Supreme Court in the challenge of the Defense of Marriage Act considers the issue, they will be considering whether the federal government is denying equal protection of the laws, even though technically the basis of this will be the Due Process Clause of the Fifth Amendment.